Ready.
All rise, the court is now in session. The Honorable Carrie Needs presiding.
Good evening, everyone. Please take your seats. All right, we will call for trial, cause number 48977, the state of Texas versus Mark Allen Chambers. Is the state ready to proceed?
Yes, Your Honor.
Is the defense ready to proceed?
Yes, Your Honor.
Are there any preliminary matters prior to bringing the jury in? All right, hearing none. Bailiff, please bring the jury in.
Jury.
Please be seated. All right, I'll call upon the state to read the indictment. Defendant, please rise.
In the name and by authority of the state of Texas, the grand juries for the county of Nita state aforesaid duly organized as such at the January term AD 2015 upon their oaths in said court present that Mark Allen Chambers on or about the 23rd day of October 2014 and anterior to the presentment of this indictment in the county of Nita and state of Texas did then and there intentionally, knowingly, or recklessly cause bodily injury to Thomas Goodfellow by striking said Thomas Goodfellow with defendant's hand. And the defendant did then and there know that the said Thomas Goodfellow was then and there public servant to wit, peace officer, and that the said Thomas Goodfellow was then and there lawfully discharging an official duty to wit, placing the defendant under arrest.
All right, Mr. Chambers, you have heard the charges read against you. How do you plead?
Not guilty.
Your plea of not guilty will be entered, and we will proceed. All right, ladies and gentlemen of the jury, the state has the burden of proof in this case, and they get to go first in making an opening statement. So is the state ready to proceed with an opening?
Yes, sir, we are. Your Honor.
All right, please proceed.
My name is Jennifer Amboise for the state of Texas. Folks, the reason why we're here is because Mark Allen Chambers was reckless. He made the conscious decision to get drunk, get behind the wheel of a vehicle, and not only risk his safety, but the safety of his wife and anyone else on the road that night. What's more, he was involved in a car accident, at which point Officer Thomas Goodfellow was dispatched to assess the scene of the accident, and in this assessment, he learned that Mark Allen Chambers was drunk. And he let Mr. Chambers know that he will be placed under arrest because of him driving under the influence. Now, folks, throughout the course of this hearing, you will learn that Mark Allen Chambers doesn't care too kindly to being told what to do. Now, I'm not sure if that's something relating to the class, status, or the position that he holds in society. He doesn't care too kindly to being told what to do. So when Officer Thomas Goodfellow asked that he interlace his fingers, place them behind his head so that he can place the handcuffs on him, he intentionally assaulted him by elbowing him in the chest, causing bruising, then attempted to reach for his sidearm, and when he unsuccessfully did that, struck Officer Goodfellow in the face, causing a laceration to his forehead. At which point, to the heat in the scuffle, with handcuffs still in hand, Officer Goodfellow struck Mark Allen Chambers in the face, was able to subdue him, put the handcuffs on him, and put him in the back of the patrol car. Now, folks, throughout the course of this hearing, you'll hear colorful theories from defense. I ask that you don't entertain these theories, but rather look at the facts. And the facts are these. Mark Allen Chambers was drunk, was driving. He intentionally, knowingly assaulted a peace officer in uniform, discharging his duties because of Mark Allen Chambers' recklessness. And what's more, causing bodily injury, bruising of the chest, and the laceration to his forehead. Now, throughout the course of this hearing, you'll hear testimony, perhaps see exhibits, and when you look at the totality of the evidence and you're ready to deliberate, you will see that the only sound, sensible, reasonable verdict to return is for the prosecution. Thank you.
All right, is there an opening statement from the defense?
Yes, Your Honor.
You may proceed.
Mark Allen Chambers is a family man, a normal man. He takes his son to ball games every now and then. He goes to his daughter's dance recital. But above all else, he is a hard-working man, a man that strives for success. And this can be seen in his most recent achievement. Nita City's largest building to this date has been 100% leased, and it provides 3,200 jobs for the people of Nita City. Because of this, the mayor, 3 council city members, and countless of Mark's colleagues toasted to his name with champagne on October the 23rd, 2014. As the night grew old, Mark Allen Chambers and his wife decided to head home so they could kiss their kids goodnight. But this would not happen because as they reached the intersection of Broadway and 21st Street, their vehicle was broadsided by a driver in a Toyota. And because of the events that followed, my client, Mark Allen Chambers, is now being charged with the assault of a peace officer. Thomas Goodfellow is a peace officer in the city of Nita. He was the first to arrive at the scene. Peace officers have many duties. And as Calvin Coolidge once said, the duties which a police officer owes to the state are of a most exacting nature. No one is compelled to choose the profession of a police officer, but having chosen it, everyone is obliged to live up to the standard of its requirements. To join that high enterprise means the surrender of it means the surrender of individual freedom. This means that if you want to be a good police officer, you have to set aside your personal prejudice. You have to set aside your bias toward people. Tonight's case is about 3 major duties that Mark Chambers, that Thomas Goodfellow broke. The first duty is the duty to set aside your personal prejudice. This is important because if all peace officers went out and detained people based on their personal prejudice, true justice would not be served. And as evidence will show, Thomas Goodfellow broke this duty the moment that in the way that he spoke to him and the way that he handled my client. Peace officers have a duty to follow procedure. This is important because without procedure, people would be stuck in a legal limbo. And as the evidence will show, Thomas Goodfellow failed to follow procedure not 1, not 2, but at least 3 times that night. The most important duty that a peace officer has is to not use excessive force. This is because people could be hiding a condition. We cannot judge just by seeing them if there's something wrong with them, if they are injured. And as the evidence will show, Thomas Goodfellow broke this duty the moment that he decided that it was okay to strike my client in the face with a pair of handcuffs, even though a few moments ago he had been in a car accident. As you all know, the prosecution in the state has the burden of proof. They will have to show you, the jurors, without a reasonable doubt, that Thomas Goodfellow acted lawfully. They will try to do this by tainting my client's name. They will sling mud at all of our witnesses. They will do everything in their power to discredit Mark Allen Chambers and our witnesses. But just remember one thing for me and my colleagues throughout this case. If you want true justice to be served, keep your eye on the ball. Goodfellow attacked Chambers. Chambers did not attack Goodfellow. Thank you.
All right. Thank you. I'd like to invoke the rule.
Yes, Your Honor.
Are there any witnesses in the courtroom who will be testifying? Yes, sir. Any witnesses in the courtroom?
Yeah, bring in the young.
Any witnesses out in the hallway, please bring them in.
All witnesses, please.
Come right up here, folks. All right, please raise your right hand. Will the defendant be testifying?
Yes.
All right. Do each of you swear or affirm the testimony you are about to offer in this matter will be the truth, the whole truth, and nothing but the truth, so help you God? Okay. The rule has been invoked. That means you cannot be in the courtroom when testimony is being received. You are not to discuss the testimony or the trial among yourselves, but only with the attorneys. Who will be the state's first witness?
First witness will be Officer Thomas Goodfellow.
Mr. Goodfellow? Mr. Goodfellow, you may remain. The rest of you please step out into the hall. Officer, take the witness stand. All right, you may proceed.
Can you please state your name to the jury?
Thomas Goodfellow.
And what is your occupation, Mr. Goodfellow?
I'm a peace officer for the city of Nita.
Can you tell me a little bit about your educational background?
I went to a 2-year college for criminal justice.
And what do you do before becoming a police officer?
I served in the military for 4 years.
And how many years have you been a peace officer?
2 years.
Were you on duty on October 23rd, 2014?
Yes, I was.
What were you wearing while on duty?
Normal Nita County Police
Well,
Department.
officer, you're gonna need to keep your voice up so the court reporter can hear. We need to have a good and accurate record, so speak up nice and loud. If you need to scoot up so she can see you better, feel free to do so. All right, continue.
Were you on duty on October 23rd, 2014?
Yes, I was.
And what were you wearing while on duty?
The Nita County Police Guard. I was wearing my badge and such.
And what vehicle were you driving that night?
The standard Nita County Police Cruiser.
Did it have any distinguishing marks to the city of Nita?
Yes, it did. It had the insignia and the lights.
Were the lights on when you responded to this event?
Yes, they were.
And what county were you patrolling that night?
Nita County.
Did anything happen around 11 p.m.?
Yes.
What happened?
I got a call from dispatch about an accident that occurred.
And what county was this in?
It was in Nita County.
What time did you arrive to the scene of the car accident?
I'd say it was around 11:40ish, 11:45.
How was visibility that night?
It was nighttime, but it was under an intersection, so it was fairly clear. It was lit up.
And how did the car accident appear before you?
I couldn't tell exactly who was at fault. It seemed like someone ran the intersection, but both cars had damage in the front side of it.
And where were the drivers at the time when you arrived?
They were arguing outside of their vehicles, but they were both towards their respective vehicle.
Which driver did you approach first?
I approached the driver of the Toyota first.
And what was your impression of him?
He seemed slightly intoxicated. He had a smell of alcohol on him.
And so after you talked to this driver of the Toyota, what did you do next?
I went over to talk to Mr. Chambers.
And what was he driving that night?
He was driving a Mercedes SLS, I believe.
And where was he when you approached him?
He was leaning against the side of his vehicle.
What was your first impression of Mr. Chambers when you arrived?
He was slightly belligerent. He was arguing with his wife at the time. He was leaning against his vehicle. He had needed help being propped up. Slightly smelled of alcohol as well.
And what did you talk about to Mr. Chambers without saying exactly what happened?
We talked about the accident, and then after that, he said how I would need to talk to him much further. He knew people in City Hall and such.
And how did the accident happen according to Mr. Chambers?
He said the driver of the Toyota ran the light and hit him.
And after you talked to Chambers, what did you do next?
After that, I called in for backup for Officer Denton.
And what did you do when Officer Denny finally arrived on the scene?
I watched him go and talk to the driver of the Toyota, and then I went over to talk to Mr. Chambers.
Was Officer Denny on the scene the entire time?
No, he left before I did.
So after Officer Denny did his test on the driver of the Toyota, what was your next course of action?
Performed sobriety tests on the Mr. Chambers.
And why did you do that?
I believe he was intoxicated.
How did the sobriety test go?
He failed all of them.
So he failed all 3 sobriety tests?
Yes, he did.
What exactly are sobriety tests?
Ways that we can tell that somebody is legally intoxicated or not, if they're fit to actually drive the vehicle.
So after he failed the test, what did you do?
I went to, I told him he was under arrest, and I went to arrest him, put the handcuffs on him.
What position was he in when you told him he was under arrest?
He had his hands behind his neck, and he was standing away from me, his back to me.
And why was he standing like this?
He had just performed the toe to heel test, and that's when, after he failed it, I told him he was under arrest.
Okay. Can you please show me how his hands were on his neck? Oh. Thank you. So to clarify one thing, you were in full police uniform. Is there any reason that Mark Chambers did not recognize you as a peace officer?
No, I showed up with my badge, my uniform on, the lights were on, and he complied with my earlier requests about talking to him about the accident.
So when you went to handcuff the defendant, what happened?
He unclasped his hands and he threw a right elbow to my chest, after which he went to, he spun around and he went for a punch.
So he elbowed you with his right elbow and then turned on you.
Mm-hmm.
And then what happened next in detail?
I stumbled back a bit. It looked like he was going to go for my firearm, but since I stumbled backwards, it seemed like he went for a punch instead, and he landed a punch
Where did you punch you?
above the right eye.
And your gun was located where?
My right hip holster.
How did you feel at this point after he punched you?
I was scared. He clearly didn't care about assaulting an officer, and then after that, he went for my pistol. So
what happened next?
after I regained my footing and he hit me above the eye, I went for a punch on him as well, and I hit him above his right eye.
With your fist, or
Yes.
was there anything in your hand at the time?
I did have the police cuffs in my right hand at the time.
What were the handcuffs in your hand at the time?
It was a fairly short altercation. I didn't have the presence of mind to throw him away at the time. I just went for the natural.
How long did this confrontation last about?
4 to 6 seconds at most.
And so what happened after you struck the defendant?
After I struck the defendant, he fell backwards and placed his hands over his face.
And then were you able to subdue?
Yes, I was.
You're a trained officer. Are you used to situations like this?
Yes, I am.
And what are you supposed to do in a situation like this?
Use appropriate force to detain the subject.
Why didn't you attempt to subdue the defendant through other means?
I felt this was the way that I could subdue him with the least damage to both of us.
So what did you do after you arrested the defendant?
After I arrested him, we both went to the hospital.
Why did you go to the hospital?
I had an injury to my chest and my head, and he had one above his right eye. I also wanted to make sure that he had no further damage from the car accident he was in.
And who was the doctor that treated you as well as the defendant?
Yeah.
What did the doctor treat you for?
She treated me for the injury to my chest and the laceration of my right eye.
And what did the doctor treat the defendant for?
For the cut above his eye as well, and yeah.
Were there any other tests that the doctor did on the defendant?
A blood test.
Did you do anything else while you were at the hospital?
No, not after the blood test, no.
After you were both treated at the hospital, what did you do next?
We went to the county jail.
Did you perform a breathalyzer test on Mr. Chambers when you got back to the county jail?
No, I didn't.
And why was that?
He didn't seem intoxicated at the time.
This is Mr. Chambers.
Oh, sorry, can you repeat the question one more time?
When you got back to Anita PD, did you perform a breathalyzer test on Mr. Chambers?
Oh, no, it wasn't necessary. I'd already taken a blood test.
No further questions, Your Honor.
Anything on cross?
Yes, Your Honor.
You may proceed.
Officer Goodfellow, you were the respondent officer in the case of this matter, right?
Yes, I was.
You administered, you said, the sobriety test?
Yes, I did to Chambers.
3 of them,
Yes.
correct? Was one of them the heel-to-toe test?
The last was.
Could you perform that to me,
Yes, I can.
please? Thank you. So you asked Mr. Chambers to put his hands on the back of his neck.
Yes, I did.
Was that relevant to the heel-to-toe test?
No.
Isn't that true that Mr. Chambers did in fact put in the position that you requested?
Yes.
At this point, he believed that he's performing the last test.
I told him he was under arrest at that point when I told him to put his arms behind his head.
Isn't it a fact that you told him he was doing very well?
Yes.
Will you agree with me that a person that has been told doing very well is caught by surprise when you told him that he was being under arrest?
That's fair, yes.
So being surprised, don't you think that he could have made by accident a sudden move and hit you with his elbow on the chest?
I don't believe the force used was responded to being surprised.
Isn't that possible that he was just reacting?
It's possible.
But he just turned around.
He lunged at me afterwards.
Does that punch, does that hit, I'm sorry. Does that, hitting you, turn you to the ground?
I stumbled back after he elbowed me, yes.
Well, you believe that when he tried to allegedly reach to your gun, wasn't trying to help you to get up?
I wouldn't believe so, considering he struck me in the head afterwards.
But is it possible?
It might be possible, but I had no indication of that was the case.
You just testified that he was stumbling around in his car.
He was stumbling around.
So a person that is stumbling around had the correct precision to turn around and hit you in the chest.
Yes.
So what you're saying is that it was not a clumsiness?
I wouldn't believe it was a clumsy hit, no.
So when you fell to the ground, you analyzed the situation. He was coming at you. That's what you thought. So your reaction was to hit him back with your handcuffs.
I never fell to the ground. I stumbled backwards, that was initially when he elbowed me. Afterwards, he went for my gun, or I believe he went for my gun, and after he couldn't grab that, he hit me in the head. So afterwards, yes, I did hit him. I didn't exactly have time to throw the handcuffs to the side, but believing that my life was endangered, I could have used more lethal force.
And you did hit him with your handcuffs.
Yes, I did.
You just testify you hit him with your fist.
That was the intention.
Isn't it possible that you attacked him instead of he attacking you?
No, it was clearly in self-defense. He had already struck me twice before I even touched him.
He struck you twice before?
Yes, he elbowed me into the chest, and then afterwards he struck me in the head before I retaliated.
Pass.
Anything further?
No, Your Honor.
All right, may sit down, sir. Thank you very much. Call your next witness.
Prosecution calls Dr. Lane Callahan.
Doctor, please come right up here and take a stand. I'll remind you, you have been sworn. All right, you may be seated.
What is your name?
Dr. Lane Callahan,
Where do you currently work?
the Middle Community Hospital.
And what is your position there?
I'm the chief of the ER.
What are your duties?
I am a physician and I direct the staff.
As a physician, what would you say is your main specialty?
Delivering emergency medicine,
What else do you specialize in?
psychiatry, neurology, toxicology, internal medicine, and I also dealt with others that are dealt with in ER.
Please explain any professional certifications or licenses you hold.
I am board certified in emergency medicine, and I also have a physician and surgeon's license from Florida and New York.
What type of units have you established in ER, if any?
I have established a head trauma unit.
Have you ever handled police cases in the ER?
Yes.
Involving what usually?
Injured people who were suspected of using alcohol.
What effects of alcohol do you study when treating those patients?
I studied the effects of alcohol on their central nervous system and their behavior.
All right, Doctor, we need you to keep your voice up nice and loud so the court reporter over here can hear you, so please speak up.
Yes, Your Honor.
How many times have you testified, giving your expert opinion in court?
More than 40.
Out of that, how many times have you testified on the nature and extent of head injuries?
At least half of that,
How many times have the courts found you to be an expert in that field?
15. At least 15.
Okay, thank you. Let's move on. Dr. Callahan, where were you on October 24th, 2014?
I was working in the ER at the Nita Community Hospital.
Did you see Mr. Thomas Goodfellow arrive at the hospital that evening?
Yes, I did.
Around what time?
Around 1:20 a.m.?
Was he alone?
No.
Who arrived with him?
The defendant?
What type of injuries, if any, were immediately visible to you at that time?
I noticed they both had cuts on their faces.
Who was your first patient?
The defendant.
What did you do to treat him?
I had the nurse take a blood sample. I also wanted to do an x-ray, but he refused.
Why was a blood sample taken?
It was medically necessary to see if he has been using alcohol or drugs.
And what time was the blood sample taken?
It was around 1:25 a.m.
Your Honor, may I approach the bench?
Yes, you may. All right, I'm sorry, go ahead. All right, let's put this all on the record. Bailiff, would you ask the jury to step out for just a moment? Ladies and gentlemen, we will have you back in momentarily. All right, please be seated. All right, now, start your argument again. What do you wish to do? Pick up this one.
Okay, we're going to explain how they treated the defendant at the hospital. We're going to explain what happened, and we're going to explain what happened with the officer. So it's necessary in order to explain what has happened throughout the case, so we have the story to make everyone understand what happened, and to make it more clear what the situation truly was. Just to make it more understandable as well, like I said.
And what evidence are you offering for this?
We're going to discuss his blood alcohol level and just how they treated him. And that's it.
All right. And
This is absolutely irrelevant. It's not relevant to the case. What he's on trial for today is for battery of a police officer. It has nothing to do with his past criminal record or anything to do with the fact that he may or may have not been drinking that night.
Well, I didn't hear anything about past criminal record. I heard that you want to introduce evidence of what essentially is the blood alcohol content from the blood sample?
Yes, or I may have left something out.
That's all right. And that's for this incident, correct?
Yes.
Now, is there a prior criminal history that is
Not that I
your...
wish to bring up right now.
Okay, okay. What's your response to that?
So just to be clear, you're not going to introduce evidence about his
No.
prior? Okay, that's fine.
Okay, then let's bring the jury back in, please.
And Your Honor, the jurors asked the lawyers to please speak up. The jurors can't hear them.
Everybody needs to speak up nice and loud, please. You folks can go ahead and take a seat. All right, please be seated, and you may continue.
Okay. Again, what time was the blood sample taken?
Around 1:25 a.m.
And what were the results of that test?
It was 0.09% alcohol by weight.
Please explain how a person would be affected if their blood alcohol level was 0.09%.
There would be
How would their judgment be impaired?
They'll be socially impaired. They will be confused.
How would their physical coordination be impaired?
It will be significantly impaired.
How would their general perception of events be impaired at a blood alcohol level of 0.09%?
A lot.
Explain how their memory function would be impaired, if at all.
It will be
Objection, Your Honor, relevance.
What's the question?
Explain how their memory function would be impaired, if at all.
What's his name?
Your Honor, prosecution moves to tender State's Exhibit 17, which is marked for identification purposes only, to opposing counsel for examination.
All right.
No objection, Your Honor.
Well, it hasn't been offered yet.
No, we don't.
Okay. Proceed.
Prosecution moves to offer Exhibit 17 into evidence.
You have to offer it and identify it through the witness.
Your Honor, may I push the witness?
You certainly may.
Do you recognize this form?
Yes, I do.
Without saying the contents of it, please explain how you recognize it.
I wrote it.
Do you see signature?
Yes,
Whose signature is it?
it's mine.
Since you wrote the document, are you familiar with its contents?
Yes, I am.
On which date did you write it?
The Nita? Date? Oh, sorry, I heard state. October 24, 2014.
And what is the document?
It is the ER record of Mark Chambers.
Your Honor, prosecution moves to enter State's Exhibit 17 into evidence.
Any objection?
No, Your Honor.
State's Exhibit 17 will be admitted.
Thank you. Under history of present illness or condition, please read lines 2 through 4 where it states the defendant's complaints and his evaluation.
Patient complained of pain to head. Patient very uncooperative, admits to drinking champagne and smells heavily of alcohol, but remains well-oriented.
What is your primary goal as an ER doctor?
To stabilize my patients.
Have you ever treated anyone who has had a concussion?
Yes.
What is a concussion?
It is when somebody strikes their head and results with a brain injury.
And what exactly is a brain injury with a concussion?
It's when you hit your heart very hard and your brain shakes, and that causes the brain injury.
What are common situations that cause concussion?
Car accidents and also football games.
What are symptoms of a concussion?
Disorientation, headaches, confusion, problems with balance, and also pupil dilation.
And what are the symptoms of alcohol intoxication?
Loss of concentration, headaches, mental confusion.
How possible is it for someone to go in the ER with a concussion and not being diagnosed with one?
Very possible, but it depends on the circumstances.
How aware were you about the fact that the defendant was involved in a car accident before arriving to the hospital on the night that you saw him?
I wasn't aware until I moved on to the next patient,
Which patient did you see after the defendant?
Thomas Goodfellow.
Your Honor, prosecution moves to tender State's Exhibit 18, which is marked for identification purposes only, to opposing counsel for examination.
Again, it has been offered.
Your Honor, may I touch the witness?
You may.
Do you recognize this form?
Yes,
Without saying the contents of it, please tell me how you recognize it.
I wrote it.
Do you see a signature?
Yes, I do.
Do you recognize the signature?
Yes,
Whose signature is it?
it's mine.
Since you wrote the document, are you familiar with its contents?
Yes,
On which date did you write it?
October 24, 2014.
What is the document?
It is the ER record of Thomas Goodfellow.
Your Honor, prosecution moves to offer Exhibit 18 into evidence.
Any objection?
No objection.
All right, State's Exhibit 18 will be admitted.
Please read the chief complaint.
Patient struck in right chest and right forehead.
Please read both lines under impression.
Right frontal chest contusion, right forehead laceration.
What is a laceration?
It is an opening on the skin.
Was Officer Goodfellow bleeding?
Yes,
Did he appear to be in pain?
yes, he was.
Did he complain of pain?
Yes,
Is that type of injury painful?
yes, it is.
What type of bandage was applied to Mr. Goodfellow's laceration?
A butterfly bandage.
What type of lacerations or butterfly bandages typically used on?
Short, deep wounds.
For what purpose are they used?
They're used to close to put the skin together and to decrease the surface area of exposed tissue.
So Mr. Goodfellow was treated with a butterfly bandage, but the defendant was treated with stitches. Why were stitches used to close the defendant's wound instead of a butterfly bandage, in your opinion?
The defendant had a cut on his scalp, so a butterfly bandage will not stay on long because of his hair. So a butterfly bandage is better used on smooth surface areas like Mr. Goodfellow's forehead, for example.
On Mr. Goodfellow's hospital report, what was stated as the cause of his laceration?
Direct hit to the chest.
What other injuries did you observe on Mr. Goodfellow?
I noticed that he was retaining on the right side of his chest, and he suffered from a chest contusion.
What is a chest contusion?
It is a deep bruise.
What typically causes a chest contusion?
Direct hit to the chest.
What are the complications of that?
It affects the skin, the muscle, the ribs, and the lungs.
After you finish treating someone in the ER and they're leaving, what further treatment would you recommend, if any?
I recommend for them to seek further treatment with another doctor or a specialist. It depends.
What did you recommend for Thomas Goodfellow to do after he saw you?
I recommended for him to follow with another doctor to seek further treatment.
How serious could Mr. Goodfellow's injuries be?
As an ER
Objection,
doctor,
Your Honor. Relevance.
Overruled.
How serious can Mr. Goodfellow's injuries be?
as an ER doctor, I am not sure. That's why I thought it was important to tell Mr. Goodfellow to follow with another doctor.
How often do patients complain of chest pain or complain of pain from chest contusions and or lacerations?
I would say always.
Did Officer Goodfellow complain?
Yes, he did.
Objection, Your Honor. Hearsay.
This is overruled. It's not what he said, but the fact that he complained.
Prosecution passes the witness.
Okay. Cross.
How are you doing today, Dr. Callahan?
I'm doing good, thank you.
Good, good. So on the night of October 23rd and into the morning of October 24th, 2014, you were on duty at Nita City Community Hospital, is that correct?
Yes,
And you had the opportunity to examine Mr. Mark Chambers.
yes, I did.
And when he came in, he was bleeding from his head, is that correct?
Yes,
Okay. And there was a good deal of blood in the victim's hair and on his face.
yes, it was.
And did you observe any injuries or damage to the defendant's knuckles?
No, I didn't
This
see.
this would be the kind of injury that would be sustained when punching someone in the head, correct?
Yes.
But there was no damage,
No,
no injury. Mr. Chambers told you how he got the wounds to his head, is that correct?
Yes, he did.
And he told you he was struck in the head with a pair of handcuffs by Thomas Goodfellow?
He didn't really tell me. I was just.
Are you sure? I'll give you another chance. Mr. Chambers told you how he got the wounds, isn't that correct?
Yes.
And he told you that he was struck in the head with a pair of handcuffs by Mr. Thomas Goodfellow?
Yes.
Okay. So he was struck in the head with a blunt instrument, the handcuffs.
Yes.
You mentioned that there was a laceration, but wasn't there also a bruise to his head as well? Both the laceration and the bruise?
Yes.
Okay. So is it possible that Mark Chambers may have been struck multiple times in the head? Since there was both the laceration and the bruise?
It could have been, but I wasn't there, so yes, it could be constantly or it could not have been.
Okay. And isn't it true that Thomas Goodfellow failed to disclose to you that he used a blunt instrument, the handcuffs, to punch
Objection,
Mark
hearsay.
Chambers in the face?
You gotta ask him, overruled. Interesting.
Isn't it true that Thomas Goodfellow failed to disclose to you that he used the handcuffs to punch Mark Chambers in the face?
Objection, relevance.
Overruled. You may answer the question.
What was the question again?
Isn't it true that Thomas Goodfellow failed to disclose to you that he used handcuffs to punch Mr. Chambers in the face?
Yes.
Okay. Now, Dr. Callahan, isn't it true that blunt force trauma to the head has been known to cause a fractured skull, brain damage, and even death?
Yes, it's possible.
Okay. So Thomas Goodfellow used potentially deadly force on Mark Chambers and failed to mention this to you, the doctor providing him care?
Yes.
It's vitally important for an ER doctor to have as much information as possible when rendering care, correct?
That's correct.
Okay. So by knowingly depriving you of that information, Thomas Goodfellow was interfering with your ability to care for Mark Chambers.
Yes.
Okay. So he put Mark Chambers' life at risk by withholding that information from you.
Yes.
Now, Mark Chambers' behavior at the hospital in the police report, it says here that he testified that he was not being compliant, and he seemed agitated. Now, that is something that could be caused by him consuming alcohol, correct?
Yes.
But it could also be caused by him being in an accident also, isn't that right?
Yes, it could be possible.
Is there any way to know conclusively why he was behaving in that manner? Whether it was due to consuming alcohol or having been in a car accident or struck in the head with a pair of handcuffs?
I would say yes, but also it depends because the symptoms could be the same for both things.
Okay. So in that case, you're saying there is no way to know conclusively why he was acting in that manner?
Yes.
Now, you talked a little bit about the blood test that was given to Mr. Chambers, and it was a .09, correct?
Yes, it was.
Okay. And you also have heard of a situation where someone who has consumed alcohol can have a rising blood alcohol concentration.
Mm-hmm.
Is that right?
Yes.
Okay. And also, when somebody consumes alcohol, their blood alcohol concentration can go down as well.
Yes.
Okay. Is there any way to know conclusively whether at that time of the night his blood alcohol concentration was rising or if it was going down?
Yes, it could have been rising. It could have been high when they arrested him, or it could have gotten high when he arrived at the hospital.
So when they arrested him, he might have been below the legal limit. That's possible, correct?
It could be possible. Or,
Okay, thank you. Is there any way to know conclusively?
no.
Thomas Goodfellow told you that he completed a full set of field sobriety tests. Isn't that correct?
Yes, he did.
Okay. How many tests does that normally account for?
About 5.
Okay, gotcha. So a full set of field sobriety tests, that's the finger to nose, heel to toe, the coin pickup, the balancing test, and counting backwards, are those the 5?
Yes.
Okay.
Objection. Relevance, she is a doctor, not a police officer. That's not something that she's knowledgeable about or she should be.
she indicated a familiarity, so at this point, I'll overrule your objection.
So if an officer completed only 2 tests, would that be completing the full set?
I don't know, I'm not aware.
So you said that a full set is 5 tests. If he only completed 2, did he complete the full 5 tests?
I cannot tell you, I don't know.
So if you know that there's a full 5 set of tests, and you know that he only completed 2 of those, did he complete the full set of tests?
As I said, I'm an ER doctor, I don't know.
No, he did not. So if he had completed all 5 of the tests, would it guarantee that he could detect intoxication? Would it guarantee that he could detect intoxication?
I don't know, it could have gone from the smell or the loss of balance.
So if an officer only completed 2 tests, that would be even less conclusive, correct?
As I said, I was not there.
Objection, the witness is non-respondent.
Been asked and answered, overruled.
When you spoke to Thomas Goodfellow at the hospital, you had a conversation with him. Did he mention during the incident that he stumbled, was not able to regain control?
Excuse me, I couldn't hear you.
So when you talked to Thomas Goodfellow at the hospital, did he mention to you that he had stumbled and fallen down?
Yes.
Okay. So he did say that he fell down on the ground?
Yes.
Okay. And did he mention anything to you about Mark Chambers reaching for his gun?
No.
Okay. And if he did tell you that information, you would have put it in your notes, correct?
I probably would have.
Okay. So in your conversation with Thomas Goodfellow at the hospital, he failed to mention the use of handcuffs to punch Mark Chambers. He failed to mention falling to the ground. And he failed to mention Mark Chambers reaching for his gun. He conveniently left all that out of the conversation, didn't he?
Yes.
Okay. So after treating Mark Chambers for the gash to his head and the contusion around it, you examined Thomas Goodfellow?
Yes, I did.
And you found a minor scratch to his head and a red spot on his chest?
Yes.
Okay. Is it possible that the scratch on Thomas Goodfellow's head could have been from the recoil when he punched Mark Chambers in the head?
It could have been, or
Okay,
not.
thank you. Isn't it also true that there's no way to know whether the bruise on Thomas Goodfellow's chest was pre-existing or unrelated to the incident?
I'm not sure.
So that's a no?
It depends. It could have or could not as well.
Okay, so it is inconclusive. It's also true that there was no way to know. I'm sorry. So is there any definitive proof that Mark Chambers caused the injuries to Thomas Goodfellow? Any definitive medical proof?
I wasn't there, as I said.
No,
So
you were the doctor who examined both of them, correct?
yes.
Okay. Is there any medical proof that shows definitively that Mark Chambers caused bodily injury to Thomas Goodfellow?
No.
In your examination, were you able to determine who initiated the altercation?
No.
Okay. So based on your medical report and your testimony in the courtroom today, there's no way to know who initiated the first contact, and there's no way to know that Mark Chambers caused bodily injury to Thomas Goodfellow.
That is correct.
So it's very possible that Thomas Goodfellow attacked Mark Chambers, and that Mark Chambers did not attack Thomas Goodfellow, correct?
I will not say yes or no because I'm not sure. It could, I don't know, I was not there. It was a fight. It was them two.
So it is possible then, correct?
It could be, but it could not.
No further questions, pass the witness.
Anything further?
No, Your Honor.
All right, Doctor, you may step down. Please call your next witness.
Your Honor, the prosecution has no more witnesses.
Prosecution arrest?
Yes, Your Honor.
All right, it is about 3-4 minutes after 5. We will take a 10-minute break. Please be back in 10 minutes.
Your Honor, we have a
All rise to the
motion. We have a motion to file.
All rise to the jury. Take the jury out. All right, please be seated. Does the defense have a motion?
Yes, Your Honor, we do. A motion for directed verdict. The prosecution has failed to prove that the defendant is Mark Allen Chambers, and they failed to prove the date on or about October 23rd, 2014, and they have failed to prove beyond a reasonable doubt that he caused bodily injury to Thomas Goodfellow.
Your Honor, Officer Goodfellow stated who the defendant was in his report, as well as when he was on the stand.
However, he did not. Did he?
Wait a minute, let him finish his response.
He did identify the date the incident happened in. And in his testimony, he identified that he was, in fact, attacked by Mark Allen Chambers.
Brief response.
Did they point him out in the courtroom? No, they did not point him out in the courtroom and identify him as the defendant. So they failed to prove that Mark Allen Chambers is the defendant. And they also failed to prove that this took place in this particular venue, Nita County, Texas.
The date and the county were discussed on several different occasions, and I'll grant you that. I do think there is a scintilla of evidence to support this, however, so we will let the jury decide. So your motion is denied. All right, please take a quick break. Be back. My mic is now on, but I don't think y'all have any trouble hearing me. I think that's the former Marine Corps sergeant, not the judge.
Thank you.
Got one, not yet. Still got two MIA. Y'all scattered.
I didn't see any. I didn't see any planes on you. Go ahead and take your seats.
Is anybody going to use this? No? Yeah, let's turn it off.
We're gonna use it on close.
You're going to use it on close? Okay. Anyway, you can.
We're just gonna use an overhead projector.
Yeah, we're just gonna use the Elmo and the overhead.
Okay, hang on. No, that's fine. Okay, so you'll just have to turn
Y'all
it on.
see where the
Just
other
gotta
one?
set that in
Yeah,
place.
she went to the store and was looking at the mobile and she was in the back.
Okay,
That's it.
But she's already fine.
Your Honor, if you like, we can go ahead and start, and she can just slip in when she comes.
Okay. All right. You ready? All right, well, you're back on the record in State v. Chambers. Defendant's present, represented by counsel. Defendant's ready to proceed.
Yes, Your Honor.
Please call your first witness.
We call the defendant, Mark Chambers.
All right, Mr. Chambers, I will remind you, you have been sworn. Please take a seat. And you may proceed.
Thank you. What is your complete name?
Mark Allen Chambers.
Is it true that you graduated with a bachelor's degree from the University of Nita?
Yes, it is.
What is your occupation?
I'm a contractor.
What were you doing on the evening in question, October 23rd, 2014?
I was at my office building.
What were you doing at your office building?
I was toasting my greatest achievement to date.
What were you celebrating?
My office building had been 100% leased. This building alone provides over 3,200 jobs for the city of Nita. The mayor was there, several council members as well.
What happened on your way home that night?
My wife and I, Pamela, we were struck by another vehicle who ran a red light.
Can you describe the damage to your vehicle?
It was damage to the front right side of the vehicle, the headlight on the right-hand side, the front end, the wheel was damaged. It was quite an impact.
What did you do after the impact?
I made sure my wife was okay, of course. We were quite shaken up. I got out of the vehicle to assess the damage.
How did you feel after the collision?
Well, I was quite shaken up, as I said. The impact was pretty severe. I felt dazed. I'm not sure if I hit my head. It all happened so fast.
When did the police arrive?
Shortly after I exited my vehicle to assess the scene.
Who was first on the scene?
I believe it was Officer Goodfellow.
Did Thomas Goodfellow perform any tests?
On me?
Yes.
Yes. He performed field sobriety tests, 2 of them, which he said I was doing great.
Okay. He just did 2 tests, correct?
Yeah, he did 2 tests. He said everything was good, and then out of nowhere, he said I was under arrest. I turned around to face him out of sheer surprise. It was confusing. I had just been in an accident. I was concerned for my wife, and I'm performing these tests over, seeking medical attention for myself, my wife, and the other driver who hit us. So I was quite shocked at this behavior. I turned around to face the man who was speaking to me, and he was startled, I guess.
What happened to your car?
After I was arrested, my wife Pamela drove the car home. The vehicle was then towed from my house. I didn't believe the vehicle to be in any safe or drivable condition. Nor did Officer Goodfellow perform any sobriety tests on my wife, Pamela, who attended the event with me earlier in the evening.
When you turned around and you said that Officer Goodfellow was startled, correct? And did he hit you first?
Yes, I turned around because we were doing these tests rather than seeking medical attention, and he said everything was fine. So I turned around to face the man after he said, "All right, you're under arrest, place your hands behind your back," and I didn't think he was serious. As I turned around, I was punched in the face. Officer Goodfellow attacked me. I'm not sure if turning around to face someone who's speaking to you would startle a normal person, but I believe that Officer Goodfellow may have had some prejudice or something like that against me.
Did he strike you with his fist?
No, he hit me in the face with his handcuffs.
With his handcuffs. As you previously stated, your car's headlight was damaged, correct?
Correct.
Goodfellow did not administer any sobriety tests to Pamela, correct?
No, he did not.
And your front right headlight was out, correct?
Correct, and it was nighttime.
And it was evening. And he let her drive home?
Yes, he did.
Pass the witness, Your Honor.
Cross.
Mr. Chambers, what were the 3 sobriety tests you were given? Do you remember?
Honestly, I was pretty dazed after the accident. I just was following his orders, going through the motions of the tests that he was having me participate in.
So there were 3, though?
It was on the 3rd one that he told me that I was under arrest.
You did just testify that there was only 2 tests.
It
So you're
was-
saying there were, in fact, 3 sobriety tests done?
He didn't even, on the first 2 tests, he said I was doing fine. Started the 3rd one, we didn't even really get into it, and he said I was under arrest.
So, in fact, you did none of the 3rd sobriety test, is what you're saying? So you
No,
didn't
no.
even start this 3rd sobriety
No,
test?
we didn't even get to that point. We finished the 2, everything was fine. I guess he wanted to go through the 3rd one, but placed me under arrest at that time.
How much did you have to drink that night?
Early in the evening, we toasted with the mayor and, like I said, some council members. with champagne. I had 2 beers with dinner.
Do you think with just two beers you're okay to drive, or how many beers do you
Objection,
think you need to
he's not
drink
an
to be
expert
drunk?
Just one.
He's not an expert witness. He cannot testify on how many.
Your Honor, I'm simply asking if the defense's opinion on a certain matter.
He's not.
Well, if you're asking for expert testimony, I will sustain the objection, but you can ask him what his sense of what he felt at the time. So as long as we don't get into too far afield into opinion, that would call for expert type testimony.
Yes, Your Honor.
Rephrase your question.
How many drinks do you personally feel you are okay to drink and then drive?
Well,
Objection, Your Honor. That's the same thing.
Overruled.
as I previously stated earlier in the evening, we toasted with champagne, and earlier in the evening with dinner, I had 2 beers.
Okay. Now, in your testimony, you state that Officer Goodfellow told you to place your hands behind your head, interlacing your fingers, and you refused to do so. Is this true?
Objection to these facts is not in evidence.
Overruled.
Please repeat the question.
Is it true that when Officer Goodfellow told you to place your hands behind your head, interlacing your fingers, you refused to do so?
Yes, this is true.
And why did you refuse that?
Because he attacked me. I was defending myself.
He attacked you when he told you to put your hands behind your head?
I turned to face the man who is now putting me under arrest rather than giving me medical
Mr.
attention.
Chambers, Mr. Chambers.
Mhm.
Before all this happened, when he was doing the balancing tests,
Mhm.
and he told you to put your hands behind your head, interlacing your fingers, did you refuse to do that?
Honestly, I don't remember. I had just been in an accident.
So as you turned to face the officer, you simply just turned to face the officer, is this correct?
Yes, it is correct. I turned around to face the man who was speaking.
So you did not in fact elbow the officer?
Not that I remember.
Is it possible that you could have hit the officer?
It is possible that I could have.
Do you think
bumped.
that if turning on an officer like this so suddenly and actually elbowing him with the force to take him off his feet could put an officer at a high state of alert?
And that's not what happened.
Then what did happen?
I turned around to face the man and he attacked me.
So you did not elbow the officer whatsoever?
No, I did not elbow the officer.
And then how did the officer obtain the bruise to his chest?
Your guess is as good as mine.
You say in your testimony that when you pulled your hands away, you might have brushed him with your elbow. Is this true?
It is possible. A lot of things happen when you're defending yourself.
Objection.
He did not say that in his testimony.
It's not.
He hasn't
possible.
testified to
He
that.
hasn't
Just one at a
testified
time.
to
Only
this.
one may make an objection.
He has not testified to this, what he's reading. This is not admitted into evidence.
I haven't heard that testimony. Sustain.
One second, Your Honor. Your Honor, I wish to admit testimony of Mark Allen Chambers. And I wish to move to tender State Exhibit 1A, which is marked for identification purposes only, to opposing counsel for examination.
All right, the way we do this is you identify the exhibit through the witness without testifying as to what it is. Then you move to admit it and show it to opposing counsel.
Your Honor, may I please approach the witness?
Ma'am.
Mr. Chambers, do you recognize this paper?
Yes, I do.
Can you tell me what this paper is?
That's a testimony that I gave.
And do your true testimony that you gave at that time? Is everything correct?
It would appear to be.
Your Honor, I wish to offer Exhibit 1A into evidence and show to the defense, tender to the defense.
What is this prior testimony from some other proceeding?
This is testimony during the commission hearing, Your Honor.
During what?
The commission hearing?
Okay. All right. If you are using it for impeachment purposes or to show a prior inconsistent statement, procedure is you ask if he has made this statement in the past. If he admits it, then it stands. If he denies it, you then show him the statement.
Yes, Your Honor.
And at that point, we'll determine if we're going to allow this to come into evidence.
Yes, Your Honor.
Okay.
Mr. Chambers, if you look at the second page, second to last paragraph, in the second sentence, starting with maybe. Can you please read that sentence?
No. You have to ask him if he has made a statement. Had you previously said something? If he admits it, then that's it. If he denies it, then you can refresh his memory with the prior inconsistent testimony.
Yes, Your Honor. Do you remember making a statement about pulling your hands away and brushing the officer?
Yes.
Can you please tell me what that was?
When I turned around to face Officer Goodfellow, I may have brushed against him. He was very close to me.
And do you think a small brush would be able to take Officer Goodfellow off of his feet? And
Absolutely
make him
not.
So maybe this was more than a slight brush.
It wasn't.
So you're saying this slight brush that you had, going to Officer Goodfellow, which is in the exact place that Officer Goodfellow does in fact have this bruise.
Objection, Your Honor, counsel's testifying.
Sustained. Rephrase.
Is it possible that this bruise on Officer Goodfellow's chest was due to you elbowing him?
No, I don't believe so.
You're saying it's not at all possible whatsoever?
I don't
Objection,
believe
Your
so.
Honor, not relevant. He's not on trial for elbowing anyone. He's on trial for striking someone with his fist.
It's a trial for assaulting a public servant.
With fist and face, not elbow.
It's all part of the process of the event that occurs. Overruled.
Mr. Chambers, so far as you've testified, you've clearly stated that you were not intoxicated that night. Is that true?
That's true.
Do you remember what happened on December 18th, 2015?
You'll have to refresh my memory.
I apologize, 2014. That was the night you were arrested. Do you remember pleading guilty to a DUI?
Objection, Your Honor. Do you have a motion to eliminate?
Your Honor, this motion only excludes this specific DUI that happened on that night.
You said December 18th.
Yes, that's when you pled guilty to this DUI.
2-1.
Yes. Yes.
So how is it relevant to the trial that we are here for today?
It's showing his state of mind at the time and why he did this.
Your Honor, his state of mind December 18th is not relevant to his state of mind on October 25th.
Your Honor, showing that he pled guilty to a DUI on this night, showing that he was in fact intoxicated.
Your Honor, it's completely irrelevant. There are other
Your,
matters.
your objection is sustained. Would you like an instruction?
Yeah?
You'd like an instruction to the jury?
Yes, Your Honor.
Ladies and gentlemen of the jury, you will be, you're instructed to disregard any evidence of a prior conviction of any kind that the defendant may have sustained.
Mr. Chambers, do you remember in your testimony stating that you punched the officer?
I defended myself.
You defended yourself?
Correct.
So you did in fact punch the officer?
When somebody's attacking you, you're going to defend yourself.
And so you were drinking that night?
As I previously stated earlier in the evening, I was toasting an achievement with the mayor and council members.
Your Honor, prosecution passes the witness.
Anything on redirect?
No, Your Honor.
All right, you may step down, sir. Please call your next witness.
Your Honor, we call Dan Allison.
Stan Allison?
Dan Allison? Dan?
Stan Allison?
Dan?
Dan Allison.
Dan? Sorry.
Mr. Allison, I don't believe you've been sworn, have you?
I have not.
All right, please raise your right hand. You swear or affirm the testimony you are about to offer in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
Please have a seat.
Thank you.
All right, you may proceed.
Thank you. What is your complete name?
It's Dana Allison.
What is your educational background?
I have an associate's degree from Nita City Community College, a bachelor's from Nita State College, and also a master's from University of Nita.
You have several publications, is that true?
Yes, I own and operate a consulting firm.
I'm sorry. Your publications?
Oh, yes, ma'am.
You published training techniques and their medical impact.
Yes, I have.
You also published effective alternatives to deadly force.
Yes.
You also published public safety impact in public events.
Yes.
What is your occupation?
I own and operate a consulting firm.
What do you consult on?
We consult on security and law enforcement conduct.
Can you elaborate on the specifics of your occupation?
Sure, we consult with, or I specifically consult with civil and criminal cases and render expert opinions concerning the conduct of law enforcement personnel.
Have you testified in the past?
Yes, more than 30 times.
Have you testified for both plaintiff and defense?
That is true.
What do you do in addition to the consulting firm?
I'm also a director for the Administration of Justice program at the Apple Valley Community College.
And what did you do before you were teaching and consulting?
I was a peace officer for Nita City
How long did you work as a peace officer?
for approximately 12 years.
What were your duties on the police force?
I was a lieutenant in the department, and I also worked as a team leader with SWAT and also a tactical squad.
When did you leave Nita City Police Department?
It's been about 10 years now.
Why did you leave Nita City Police Department?
The hours and the stress of all those duties kind of built up, and so I needed to take myself out of that.
So would you say that you had some personal issues you needed to address?
Yes, and I dealt that with counseling and effective rehabilitation.
Can you explain to us the concept of bystandership?
Sure, it refers to the responsibility of each officer has to one another to ensure both proper procedural.
Slow down, please. The court reporter needs to get down everything that you say.
My
and I have to
apologies.
hear it, as does the jury.
The term refers to the responsibility to each officer that they have to one another to ensure both proper procedural handling and safety.
On the night of the incident, did Officer Goodfellow demonstrate bystandership?
No, not in my opinion.
In what way did he fail to demonstrate it?
Well, Officer Goodfellow's decision to allow Officer Denny to leave before he conducted the field sobriety tests on Mr. Chambers was an exercise in poor judgment, in my opinion.
How many field sobriety tests are part of proper procedure?
Normally there are 5.
Would 3 field sobriety tests be enough to come to a reasonable conclusion on whether someone is intoxicated or not?
No, that would not be, in my experience as a peace officer, the proper procedure is to complete the whole 5 tests.
After reviewing the case, how many field sobriety tests did Thomas Goodfellow complete before arresting Mark Chambers?
He only completed 2. From what I can tell, he started the 3rd, which is the heel to toe test, but did not complete that.
In your opinion, is it wise to deceive a DUI subject?
No, it's not consistent with police practice to play tricks on a suspect.
What benefits would there be for another officer to be present at the time of one officer arresting a suspect?
If another officer was present, that officer could assist in controlling the suspect's behavior through non-forceful means, such as either explaining what's going on or apologizing for the ruse.
Do you think the whole situation could have been avoided if if Officer Denny did not leave?
I believe it could have been mitigated.
Does police training authorize the use of handcuffs to strike an individual?
No, there's no manual or police course that has ever authorized using handcuffs to strike a subject.
What is a procedure for restraining a subject?
Well, there are 4 different levels.
What are the 4 levels?
Level 1 is verbal directive. Level 2 is the use of control holds, where you hold a suspect to restrain them. Level 3 involves either a baton or possibly a chemical weapon, which is something like pepper spray or mace. And level 4 is deadly force.
Which level does striking a subject with handcuffs in the face fall under?
That would be considered level 4 as a deadly force.
Thank you. Pass the witness.
Anything on cross-examination?
Yes, Your Honor. You said that in level 4 situation, a deadly force situation, that an officer is authorized to use a deadly instrument to defend themselves. In your testimony, you said that handcuffs can be used to defend oneself when it's a deadly force situation, right?
In a deadly force situation, that's level 4.
You also said in your testimony that if the defendant was going for Officer Goodfellow's gun, that it'd be reasonable and appropriate for Officer Goodfellow to use deadly force. Isn't that true?
He did not say that in his testimony.
No, that has not been the testimony. The objection is sustained.
Your Honor, may I approach the witness?
Yes, you may.
Thank you.
Do you recognize those documents?
Yes,
Did you write them?
I did.
You remember writing them?
I do.
Did you write them after
Did you write them in response to the defense when they were explaining trial to you? And
Yes, ma'am.
okay. So now that you've had time to look at your testimony, or
It's not.
Or it's
That's
a
actually-
report.
Objection, Your Honor, it's not testimony. He's an expert witness, and this is expert findings on the situation. This is not
Okay.
testimony.
Identify what these are,
What?
if it's a written report, and then formally offered in evidence.
What is that?
This is a written report that was requested by the defense that I wrote for them after reviewing.
Your Honor, prosecution moves to offer Exhibit 5A into evidence.
Any objection?
No.
States Exhibit 5A will be admitted.
So in your expert report, you said that handcuffs can be used to defend oneself in a deadly force situation, right?
Only in deadly force situation.
Okay. You also said that if the defendant was going for Officer Goodfellow's gun,
Slow down so the reporter can get that all down so I can hear.
then it'd be reasonable and appropriate for Officer Goodfellow to use deadly force. Isn't that true?
If he was going for the gun specifically, he could potentially use handcuffs as deadly force.
So if Officer Goodfellow was attacked by the defendant, and the defendant went for the officer's gun, you're saying that the officer used a reasonable amount of force to subdue him?
It would depend on the circumstances of the situation.
Okay. You've testified about the conduct of law enforcement personnel at least 30 times.
Correct.
Is that true? You don't testify often for prosecution, do you?
I've testified for prosecution and defense.
You don't testify for prosecution half of the time, do you?
It's mainly defense.
So you mostly testify for the defense in criminal cases, that's true?
That is correct.
Do you prefer to assume that police act unlawfully?
Not at all.
What was the name of the article that you wrote for the NIDA Criminal Defense Counsel Association?
Off the top of my head, I cannot remember at this moment.
Wasn't it called Assumption of Lawful Police Conduct Can Be Dangerous?
That sounds right.
Do you have a personal preference on the amount of force police officers use?
I would prefer as little as possible unless the situation absolutely dictates it.
So you do have a preference on how police officers act?
I believe that deadly force should not be used unless it's an absolute emergency situation.
Do you have any financial interest in this case?
I have received payment, but
Objection, Your Honor, the relevance.
Objection, not relevant.
I'm attempting to prove bias.
Overruled.
Has a criminal defense attorney ever paid you to testify in court?
that is correct. But that's normal of all expert
How much are you being paid
witnesses.
right now as you testify?
For this case, I've been paid $2,800.
But right now you're being paid $1,000 right now as
$1,000
you
to
sit there.
testify.
Did you request the defense pay your travel expenses as well in addition to that?
Yes.
And did they?
Yes.
After giving your opinion to the defense in your expert report, you offered to be their expert witness if they paid you more money. Isn't that true?
Yes.
Do you have any
Objection, Your
personal
Honor,
interest?
relevance.
Overruled.
Objection, Your Honor, badgering the witness.
Overruled.
Do you have any personal interest in the outcome of this case?
I do not.
This case involves a peace officer who works for NIDA PD. Are you aware of that?
That is correct.
Didn't you say earlier that you spent 12 years working for NIDA PD?
I did.
Until you resigned, right?
That's correct.
Did you resign to possibly avoid facing disciplinary action?
Not that, no. I resigned because of the stress and the hours of all the duties that I had.
Didn't you say you stopped performing your duties for NIDA PD because you were stressed?
I did.
And even though you weren't performing your duties, you still wanted to be paid, right?
Well, that's why I started my consulting firm.
Would you like to review your testimony for a few seconds to refresh your memory?
Objection, Your Honor, he did not testify.
Or your
That's not-
expert witness report?
Please review your
Sure
report.
thing. Would you be able to point out exactly where that's at?
It is on the last page. It's the last page and the second to last paragraph.
Okay.
Do you see it yet? My question was...
Well, yes. No, I did request that they compensate me while going through counseling.
Okay, so let me say my question again.
Sure.
Even though you weren't performing your duties, you still wanted to be paid, right?
I was requesting compensation while going through this counseling so that I could further work for...
Your counseling?
Mm-hmm.
Would you like to explain what that counseling was for?
It was for alcohol.
Nita PD didn't pay you like you wanted, did they?
That's correct.
And you didn't like the way they handled your situation, did you?
No, I did not.
Thank you. Your Honor, prosecution passes the witness.
Anything further?
Yes, we'd like to redirect.
You may.
Is it typical for an expert witness to be paid for their testimony?
Yes, it's the vast majority of the time that an expert witness will get paid for their testimony.
Are you running a nonprofit as your consultant firm? Is it a nonprofit?
Correct. No.
Is
It is a for-profit.
it is your job to be a consultant on these type of cases, correct?
Yes, I do have a consulting firm.
And you expect payments for
That
your
is
job?
correct for both prosecution.
One at a time, please. Later, question before you begin your answer. Let
My
him finish his
apologies.
answer before you begin your next question.
Is it uncommon for an expert to be paid? Is it common practice for an expert to be paid more than what you were being paid for this, for consulting on this case?
It ranges.
Would you say that you were doing anything out of the ordinary, requesting payments for your services?
No, I spent 6 hours of research of the case and the standard trial fee.
Thank you, pass.
Anything on recross?
Yes, Your Honor.
You may proceed.
You were talking about consulting as your job, correct?
Yes, ma'am.
You consult with security and law enforcement.
That is correct.
You consult with corporations and government agencies on the design of security systems.
Yes.
That's what's on your resume. Do you remember that?
Yes.
So that's what you consult with, security systems, right?
Correct.
You consult with security systems.
Objection, Your Honor, ask and answer.
Sustain.
So what are you talking about when you're saying you're consulting and that's your job when your resume states that you consult with security systems? I don't understand. Can you please explain?
How law enforcement and private security conducts matters of detaining somebody and handling their business without going over the edge to use deadly force.
Well, it seems like what you're saying is that you consult with people and your job is an expert witness and it's your job to consult about law enforcement conduct. That's what it sounds like. Is that true?
Objection, Your Honor, ask and answer.
Overruled.
Are you saying that's
Sorry, ask that again.
Are you saying your job is to consult about law enforcement conduct? That's what consultant means?
Part of it, yes. So, yes.
Your Honor, may I approach the witness?
You may.
I am handing the witness State's Exhibit 5, which is... Do you recognize this document?
Yes, I do.
How do you recognize it?
This is my resume, my curriculum Bate.
You wrote it, right?
I did.
Do you remember writing it?
Yes.
So, can you take some time to look over your duties as your job as a consultant and what you consult about, just to refresh your memory on that?
A small amount.
I consult with corporations and governmental agencies in the design of security systems. I've worked with NIDA Supreme Court, Amicon Corporation, and various others.
Okay, so now that you've read that, and you said before that you consult about the conduct of law enforcement personnel, would you like to change your mind and after looking at that, and tell us what you consult about?
Well, as I just stated, I consult with corporations and governmental agencies, including police officers.
On security systems, you consult with security systems, right?
That's true.
That's your job?
Objection, Your Honor, it also says consultants on security and law enforcement conduct. I don't.
You can do that on redirect. This is cross-examination.
Got it.
Please proceed.
Prosecution passes the witness.
Anything on redirect?
Yes.
Briefly.
Yes. On this same document that you're looking at.
Yes.
Does it not say that you consult on security and law enforcement conduct?
Yes, it does.
Also, to go for your knowledge, you spent 12 years with Yuba City Police Department, correct?
That is correct, in various fashion, in various positions.
Thank you. Pass.
Anything further?
No, Your Honor.
All right, you may step down. Thank you, you may
Thank
step
you.
down. All right, please call your next witness.
Yes, Your Honor. We call Leslie Wyatt to the stand.
Leslie Wyatt.
White or white?
Wyatt? Wyatt?
Wyatt. Right, have you been sworn? I don't believe so, have you?
No.
All right, please raise your right hand. You swear or affirm the testimony you're about to offer in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Please have a seat. All right, please proceed.
Thank you. What is your complete name?
Leslie Wyatt.
Are you a veteran?
Yes.
How long did you serve?
7 years.
Why did you leave the Army?
Oh, I'm sorry, 4 years. Why did I leave the Army? I became disabled.
7 years ago, you were in the hospital, correct?
Yes.
Why were you in the hospital?
Personal issues?
Are you seeing a specialist for these personal issues?
Yes.
Do you take medication every day?
Yes.
Did you take your medication on the day of the incident?
Yes.
Where were you at the time of the accident?
I was walking back to my home
Where do you live?
at the Ritz Hotel,
Where is the Ritz Hotel located?
21st and Yale,
How far is that from the accident?
about a block.
Did you see the car accident?
No, I did not.
How did you know the car accident happened?
I heard the accident.
What did you do when you heard the car accident happen?
I went towards the accident to see what happened.
Did you see Thomas Goodfellow arrive on the scene?
Yes, I did.
Did you see how the altercation began?
Yes.
Did you see Thomas Goodfellow take out his handcuffs?
Yes, I did.
Did you see Thomas Goodfellow attack Mark Chambers?
What do you mean attack? Like physically attack?
Yeah, did
Yes. Yeah.
Would you then say you saw Thomas Goodfellow attack Mark Chambers and Mark Chambers did not attack Thomas Goodfellow, correct?
Yes.
Did you speak to Thomas Goodfellow?
No, I did not.
Let me give you a chance to amend that. Did you? I was trying to do it formally, but you know. Did you speak to Thomas Goodfellow that night?
Yes.
Can you recall what he said?
No.
Did he take a statement from you that night?
No.
And you were a witness to the event that happened?
To
The incident.
Oh,
between Thomas
between
and-
them two? Yes.
You were witnessing, he did not take your statement, correct?
No.
Thank you. Pass.
Cross?
Yes, Your Honor. Ms. Wyatt, so it is true that you were in the Veterans Hospital for 3 years?
For 3 years? In the hospital?
Yes, the Veterans Hospital.
Mm-hmm.
And why were you sent to this hospital?
Personal issues.
What were these personal issues?
Personal issues.
What do you do for work, Ms. Wyatt?
I'm disabled.
So you cannot work?
Yes, I do not work.
And what is your disability?
I don't know.
Is it true that you take medication daily
Yes.
for this condition?
Yes.
Can you tell me the name of this medication?
No, I cannot. I
Why
don't
can't
remember.
you don't remember this medication, but you take it daily?
Mm-hmm. It's a really long word.
Have you ever missed a day of taking this medication?
No.
Have you ever been arrested by the Needy County Police?
Maybe.
Yeah.
Would any document help you remember that?
Yes.
Your Honor, may I please approach the witness?
You certainly may.
Okay.
All right, I'll ask the question again. Have you ever been arrested by the Needy County Police?
Yes.
Objection, Your Honor, relevance. Objection, Your Honor, relevance.
Your Honor, I'm attempting to show bias in the witness.
Through an arrest?
Yes, Your Honor.
This has nothing to do with her actually witnessing the event that took place that night. We're trying to get into her past, which has no bearing on this case whatsoever.
Your Honor, trying to show that Ms. Wyatt has vendetta against the police department.
All right, lay a better predicate to raise those issues, and then perhaps we can go in.
Yes, Your Honor. Ms. Wyatt, what's your personal opinion about police officers?
They're good people, protect the community.
So they're good people, you're saying, and they protect the community.
Mm-hmm.
Do you ever remember, in your letter to the police commission, do you remember writing that letter?
Yes, I remember writing it.
Objection, Your Honor, relevance.
Your Honor, I am trying to show
Is the letter
bias.
she had wrote to the police commission concerning this incident?
Yes, sir, Your Honor.
All right, the objection's over. Move along, quickly.
Do you remember calling officers certain names in this letter?
Objection, Your Honor, this assumes facts that are not admitted in evidence.
Your Honor, may I please approach the witness?
Yes.
Do you remember writing this letter?
Yes.
What is this letter for?
To inform about the incident that happened that evening.
And which incident are we talking about here?
The officer attacking.
Objection, Your Honor, this is hearsay.
It's her letter.
Attacking the. I can't think of the name.
And at the very bottom of it, is that your name that you signed on this letter?
I didn't sign it, but I typed it.
Okay. Your Honor, prosecution wishes to enter Exhibit 22 into evidence.
Any objection? State's Exhibit 22 will be admitted.
In your first sentence there, when you say, after I am a citizen of Nia City and you are outraged, can you please read that next sentence to me?
Starting with October 23rd?
Yes, please.
Okay. On October 23rd of this year, I witnessed a savage beating of a man by one of Nia City's.
Nice and loud, please.
Can we check on time here? Can we check the time?
Move on.
On October 23rd of this year, I witnessed a savage beating of a man by one of Nia City's facet cops.
Is that word fascist?
Oh, sorry, fascist, yes.
At the very bottom of this letter, can you please read the very last paragraph for me?
And while you are at it, if you decide to keep this person on the police department, I suggest that he be required to wear this.
And what is that symbol at the very bottom left that you were referring to?
Objection, Your Honor, this is inflammatory.
Overruled.
A Nazi symbol?
This is the Nazi symbol that you were wishing that the entire Nita City Police Department wear. Is this true?
That's what I said.
And
No, actually, I said he should be required to, not the whole department.
And who is this that you told that you were saying to wear this?
Which officer?
Yes.
Goodfellow?
And do you also, Your Honor, prosecution has to witness.
Anything further?
No.
All right, you may step down, ma'am. Thank you very much. Anything further from the defense?
No, Your Honor.
All right, are we ready to proceed to arguments?
Yes.
Yes, sure.
Okay. All right, ladies and gentlemen, I'm going to read you the charge of the court. A lot of definitions and questions in here. Don't be daunted by them.
I'm sorry, Your Honor, could we have a 10-minute break?
You want to take a break?
Yes, sir.
All right, let's take a 10-minute break then.
Yeah. Like herding cats. Yeah.
Yes, everybody can come in.
Everybody can come in?
Now, the witnesses are released from the rule, they can come in. Have the jury come in. Go ahead and take a seat, ladies. All right, we are back on the record. The defendant is present, represented by counsel. Ladies and gentlemen, I'll now read you the charge of the court. It has a lot of definitions. Don't be daunted by that. You'll have an opportunity to take this back with you and get an idea of what the attorneys will be arguing to you and how they want you to answer the questions posed at the end. Cause number 48977, State of Texas versus Mark Allen Chambers. Charge of the court. Ladies and gentlemen of the jury. The defendant, Mark Allen Chambers, stands charged by indictment with the offense of assault on a public servant, alleged to have been committed on or about the 23rd day of October, AD 2014, in Nita County, Texas. To this charge, the defendant has pleaded not guilty. Our law provides that a person commits the offense of assault if he intentionally, knowingly, or recklessly causes bodily injury to another. Such assault is an assault on a public servant when committed against a person the actor knows is a public servant, while the public servant is lawfully discharging an official duty. A public servant means a person elected, selected, appointed, employed, or otherwise designated as an officer, employee, or agent of the government. The actor is presumed to have known the person assaulted was a public servant if the person was wearing a distinctive uniform or badge indicating the person's employment as a public servant. Bodily injury means physical pain, illness, or any impairment of physical condition. A person acts intentionally or with intent with respect to the nature of his conduct or to a result of his conduct when it is his conscious, objective, or desire to engage in the conduct or cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to circumstances surrounding his conduct or the result of his conduct when he is aware but consciously disregards a substantial and justifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. Now, if you believe from the evidence beyond a reasonable doubt that on or about the 23rd day of October, AD 2014, in Nita County, Texas, the defendant, Mark Allen Chambers, did then and there intentionally, knowingly, or recklessly cause bodily injury to Thomas Goodfellow by striking the said Thomas Goodfellow with defendant's hand, and the defendant did then and there know that the said Thomas Goodfellow was then and there a public servant, to wit, a peace officer, and that the said Thomas Goodfellow was then and there lawfully discharging an official duty, to wit, attempting to detain and or arrest and or restrain the said defendant, then you will find the defendant guilty as charged in the indictment. Unless you so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will acquit the defendant and say by your verdict, not guilty. Prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to their testimony. But the law you must be governed by and shall receive in these written instructions. After you retire to the jury room, you should select one of your members as your foreperson. It is his or her duty to preside at your deliberations, vote with you, and when you have unanimously agreed upon a verdict, to certify to your verdict by using the appropriate form attached hereto and signing the same as foreperson. Your sole duty at this time is to determine the guilt or innocence of the defendant under the indictment in this case, and restrict your deliberations solely to the issue of guilt or innocence of the defendant. Following the argument of counsel, you will retire and to consider your verdict. Suitable forms for your verdict are hereto attached. Your verdict must be in writing and signed by your foreperson. I have now signed as the presiding judge. On the back is a verdict form. Top it reads, verdict, we the jury find the defendant, Mark Allen Chambers, guilty of the offense of assault of a public servant as alleged in the indictment, and a signature line for your foreperson. Under that, we the jury find the defendant, Mark Allen Chambers, not guilty, and a signature line for your foreperson. All right, at this time, recognize the state for closing argument.
As a law enforcement officer, my fundamental duty is to serve mankind, to safeguard lives and property, to protect the innocent from to protect lives from innocence and oppression, the weak against oppression and intimidation, and the peaceful against violence and disorder, and to respect the constitutional rights of all persons to liberty, equality, and justice. This is the oath Officer Goodfellow took before he was sworn in to the Nita County Police Department. This is the oath that Officer Goodfellow was upholding the night he was attempting to arrest the defendant. Simply put, Officer Goodfellow was just upholding this oath and doing his job the night he was unexpectedly assaulted by the defendant. And this is what this case is about: assault. But not just assault on anybody, assault on a peace officer. Now, it was mentioned multiple times throughout the case that the defendant was toasting with the mayor earlier that evening. Does this give him any right to assault a peace officer? It was also mentioned that the defendant was attempting to reach for the officer's firearm. Now, in that situation, Officer Goodfellow became afraid for his life and went on survival mode and reacted as such. If he had not done so, you may not have seen him here tonight. Now, I have 3 questions for you. Who keeps our children safe? Who keeps our streets safe? Who keeps our community safe? Thomas Goodfellow, a veteran, a family man, an officer of the law who was assaulted while upholding this oath and is doing his job. Let Officer Goodfellow do his job and find the defendant guilty. Thank you.
Thank you. All right, from the defense?
There's something I'd like to place on the Elmo. Author Sarah Strohmeyer says, "The imagination is a wonderful thing." And if you've ever seen children at play, you know this to be true. I had the pleasure of sitting with my children the other day and watching them play. And the imagination really is a wonderful thing. It's almost as wonderful and beautiful as my children are. And the great thing about when children play, they have this amazing way of taking physical objects and making their stories more realistic and believable. This evidence connects the world of the imaginary to the physical world. This evidence connects the imagination to reality. In this courtroom today, the prosecution has attempted to get us wrapped up in their imagination, in their story, in their version of the truth. They've given us nothing physical to latch onto, nothing solid to rely on, no proof that this imaginary world that they've created actually exists. Instead, what they've done is they've spent their time attacking the character of my client, attacking the credibility of my witnesses, and attacking the truth of this case. I had the pleasure of taking my son to his first Astros game the other day. We had a great time. We walked around the ballpark, we ate hot dogs, we even met Orbit, the team mascot. And in preparation for this game, I've been reading to him from a book about how the game of baseball originated, how it started. And I shared with him, father to son, the age-old #1 rule of baseball: keep your eye on the ball. I'm sure many of you today in this courtroom have spent time cheering on little ones in their various activities. I can remember playing in Little League and hearing my mom and dad shout from the stands, "Keep your eye on the ball." And that's what we're asking you to do today. That's what my colleague, Mr. Trevino, asked you to do in his opening. Keep your eye on the ball. Do not be distracted by the mudslinging of the prosecution. Mr. Trevino addressed you in opening, and he told you that this case is about 3 things. Thomas Goodfellow's duty to lay aside personal prejudice, his duty to follow procedure, and his duty to not use excessive force. And we've seen throughout the course of this trial that he very clearly violated each of those 3 duties. In fact, whenever he took the handcuffs and he brutally attacked my client and wrongfully arrested him, he was no longer operating in the capacity of a peace officer. He was no longer a police officer seeking to protect and to serve. He became an attacker. He became an assailant. He became a rogue. This case is about his duty to this city and to us as citizens, but it's also about 3 other things. It's about accountability, self-defense, and fear. The Nita City Police Department must be held accountable for their actions and for the actions of their police officers. The Nita Police Department knew that Thomas Goodfellow
had some things going on in his personal life that could prevent him from lawfully discharging his duties as a police officer, and they did nothing. They absolutely
Objection, Your
did
Honor.
nothing to
Got
stop that.
objection. What is your objection?
Motion eliminating against.
I
Bringing
didn't bring up anything.
Let him make his objection.
Objection to the bringing up of personal prejudice.
This is closing argument overruled. Jury will be guided by the evidence they have heard. We're asking for your collective memories in reaching a verdict. Please proceed.
They failed to get him the help that he needed. James Monroe said that the right of self-defense never ceases. It is among the most sacred and alike necessary to both nations and to individuals. Each person has an absolute right to self-defense. When Thomas Goodfellow took those handcuffs and started smacking Mark Chambers in the face with this, he had a necessary right to defend his life. Terrorism defined is the use of fear and intimidation to bring about some sort of political motive. Thomas Goodfellow used fear and intimidation. You see, he knew Mark Chambers, and he knew that Mark Chambers, among other things, wanted to build a ballpark for the city of Nita, for its citizens. Thomas Goodfellow also wanted those funds used for higher salaries for himself and his fellow officers. He used violence and intimidation, not just on Mark Chambers, but on Leslie Wyatt and many others as well. The question today is, who's next? If Thomas Goodfellow, if the Nita City Police Department, if they're not held accountable for their actions, who's next? On the night of October 23rd, 2014, Mark and Pam Chambers were driving home from a celebration when they were struck by a driver who ran a red light. Officer Goodfellow arrived on the scene, and he recognized a dazed and confused Mark Chambers, and he took advantage of the situation. We've heard from several witnesses today. Thomas Goodfellow himself took the stand, and he admitted to taking handcuffs into his hands and punching Mark Chambers in the head. He admitted that he let Officer Denny leave the scene and violated the procedure of bystandership. Mark Chambers himself took the stand, and he did so. He did not take the fifth. He didn't have to take the stand. He gladly went up there because he wants to clear his name in this community, and he wants to hold the police department and the officers who work for the police department accountable for their actions. We heard from the prosecution's expert witness, Dr. Callahan, who testified that there is no medical proof, no evidence to prove that Mark Chambers attacked Thomas Goodfellow. There is no medical proof or evidence that proves beyond a reasonable doubt that Mark Chambers caused bodily injury to Thomas Goodfellow. We also heard from Dr. Lane Callahan that upon arriving to the hospital, Thomas Goodfellow withheld vital information that put my client's life in jeopardy. We heard from Leslie Wyatt, the only witness who actually saw this altercation take place. Now, the prosecution would like to discredit her because of her past, but she saw what took place that night. She saw Thomas Goodfellow attack Mark Chambers. She did not see Mark Chambers attack Thomas Goodfellow. We heard from the defense's expert witness, Dan Allison, and he talked a little bit about Thomas Goodfellow's lapse in law enforcement judgment, and that he had a lapse in judgment in regard to bystandership, letting Officer Denny leave the scene. He had a lapse in judgment when he aborted the field sobriety test halfway through. He had a lapse in judgment when he played a trick on the defendant. He had a lapse in judgment when he took the handcuffs, put them around his knuckles, and began to hit Mark Chambers in the head. He refused my client access to a breath, urine, and blood test. He waited for the hospital to do that. All things that he could have done. Nita City Police Department has a responsibility to ensure that officers like Thomas Goodfellow don't engage in this sort of activity. The prosecution has brought up the fact that Mark Chambers was drinking that night. In testimony, Dr. Lynn Callahan testified that her medical report shows he had a 0.09 blood alcohol concentration. The legal limit is 0.08. We're talking about 0.01%. We're talking about the difference between 1 penny and 2 pennies. Dr. Lynn Callahan also testified that it's very possible that his blood alcohol concentration could have risen above the legal limit. That at the time that this altercation took place, he may not have even have been intoxicated. He might have been in the process of being wrongfully arrested, just like he said, after being hit in a violent collision. Let's talk a little bit about the jury instructions that the judge just gave to us. At the time that this took place, Thomas Goodfellow was not lawfully discharging his duties as a public servant. When he made the decision to use excessive force on Mark Chambers, he stepped outside of those duties, he laid down his badge, and he picked up a weapon, and he began to pummel my client. There is no evidence other than Thomas Goodfellow's testimony that any injury was caused by Mark Chambers. Mark Chambers cannot be convicted of this crime based on one man's testimony. Based on one man's testimony, we have not met the burden of proof. The prosecution hasn't. He can't be convicted of this crime because he did not intentionally, knowingly, or recklessly cause bodily injury to Thomas Goodfellow. Because when Thomas Goodfellow attacked him, all he did was merely defend his life. It's a heavy burden of proof beyond a reasonable doubt. The prosecution has made their case, and they've been found wanting. They have not met their burden of proof. On the screen here, we have the levels, and you see they have to be above reasonable doubt. That means if there's any question in your mind whether or not our client is guilty, you must acquit him. They've provided not a single stitch of real, tangible evidence that proves the story that they've presented here today. This city is the city where many of us grew up. It's the city where many of us are raising our children, watching maybe our grandchildren, or for some great-grandchildren grow up. It's up to us to hold this city and their police officers accountable for their actions, because if we don't, no one else will. Mark Chambers did not commit this crime, and he cannot be convicted for it. He's on trial right now today with his life hanging in the balance. Today, this is about doing what's right. This is about making the right decision, not just for Mr. Chambers, but for our community, for our children, for our grandchildren. It's about doing what's right. Thomas Goodfellow attacked Mark Chambers. Mark Chambers did not attack Thomas Goodfellow.
All right, ladies and gentlemen, as I told you, the prosecution has the burden to prove this case beyond a reasonable doubt. Therefore, they get to open and close. I'll call upon the state for a rebuttal.
May I push the...
Yes.
Thank you.
want you to imagine a badge. Badges are used to show status, position, career, life. A policeman's badge, for instance, carries two things. Carries responsibility. It also carries the promise. I want to remind you all that this is an assault case, for which Mark Chambers is here today, and which you're here to judge. And I want you to imagine the weight and the burden of wearing a badge. You heard the events that happened today. Officer Goodfellow arrives at the scene. Two-car collision. Both witnesses are one witness is being questioned by an officer. The other one is waiting patiently. Officer Goodfellow, after talking to the other defendant, the other victim, Goodfellow arrives to the defendant. After talking to the other victim, Goodfellow arrives to the defendant. During the conversation, Goodfellow could detect the stench of alcohol on his breath. Continuing their conversation, the defendant was wobbling. He had to lean on his car because there were two instances where he fell over. Almost fell over. Almost fell over. Officer Goodfellow then proceeded to go ahead with sobriety tests. After failing the first two, the defendant was starting the third. During the third, Goodfellow told the defendant he was going to be arrested. Now, usually, what Officer Goodfellow said earlier, whenever he moves into to arrest somebody, they hold their hands like this. The defendant, after hearing who's being arrested, slams his right elbow against the officer's chest, turns around, punches him, and lunges for his gun. That act, that moment of defiance was why we were here. That defiance of a police officer's orders and the physical assault on him is why we are here. Now I ask you, what kind of person defies a police officer's orders? What kind of person lunges for a police officer's gun? I mean, that's the first thing I notice whenever I see a police officer, a bailiff, okay, gun or badge. Goodfellow reacts to his assault, thankfully subdues him and arrests him. Officer Goodfellow wears the badge of Nita, Texas. He holds that right here, like what the bailiff has, his badge right there, all over his heart. He knows the weight and he knows the promise that he has to wear every day. Every morning he gets up wearing the uniform, putting on the badge. want to remind you again, Mark Chambers, while assaulted Officer Goodfellow when he knew he was going to be arrested. He injured Officer Goodfellow, and he knew what he was doing. He hit the officer. He intentionally, recklessly, and knowingly assaulted the officer. It's people like Officer Goodfellow who we want to protect our community. It's how we want to keep us safe during the day and night. Is this how we thank our officers? Question their motives, question how they follow procedure? The defendant acted recklessly, intentionally, and knowingly against a peace officer. If you don't find him guilty, what's it going to take? Find him guilty. Find him guilty. Thank you, Your Honor.
All right, ladies and gentlemen, you've now heard all the evidence. You've read the court's charge. You've heard the summation by counsel. Bailiff, let me give you the court's charge. We will ask you now to please retire to your deliberation room, and we will await your verdict. All rise for the jury, please. Please be seated. All right, please be seated. Madam Foreperson, it appears the jury has reached a verdict. Is that correct?
That is correct.
Would you hand the verdict form to the bailiff, please? All right, Mr. Chambers, if you will please stand. This is a unanimous verdict of all the members of the jury.
It
Correct?
is.
All right. We, the jury, found the defendant, Mark Allen Chambers, guilty of the offense of assault on a public servant as charged in the indictment. We'll now go into the punishment phase. All right. Thank you, ladies and gentlemen. You are now discharged. All right. Any other questions, comments, etc.? All right, guys. I really appreciate it.
If anybody would like to talk to the lawyers, they're available. If you need to go, they can understand. Would they have questions for us? I'm sure they would. Would like to hear